truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey everybody. My apologies. Dallas locked her keys inside her car, and I was busy trying to help her to get in, and then we ended up having to call the police, and the police let her open the car door and all that. We were calling the locksmith, and they were saying it was going to take hours because it's rush hour and things like that. So it was like, what can we do? I said, well, we can call the police. She's like, Ma, no. I was like, call the police. So there was a policeman behind me, right? And because I was on the phone with her, the policeman was behind me. So I stopped my car and I got out and I went over to the policeman. And I said, do you guys still help people with cars that's locked out? He says, yeah, sure. I said, well, my daughter's locked out and she's near the gas station. So he was like, well, I'm going to a call right now, but just call 911 and they'll get somebody over there. So I ended up calling 911 and I told them it's not an emergency. Can you transfer me to a non-emergency? She's like, oh, I can help you right here. So I called and was able to get her in her car and everything went fine. So that's what took me so long. My apologies for my tardiness, but it was not meant. It wasn't on purpose. I just had to make sure my child was okay. All right, but that was it. Thank you, Tall Glass, for the 10 jewels. I appreciate you. Thank you so much. I appreciate you for that. Naughty Lynn, new membership? What happened? Well, I know you was a member before, so what happened? Naughty, they took your membership away. Hey, everybody that's in this chat. Tonight, guys, I am going to go over some cases that I will be doing. And I will be giving you the updates of particular cases, right? One case I want to bring to you guys' attention, which is going to come up in September. You guys remember Boosie was arrested, right? He wasn't arrested. No, he wasn't arrested. Well, was he arrested when the Texas situation? Did they arrest him? Did they arrest him? I'm not sure. I don't remember if they arrested him. But anyway, remember he had a case in Texas regarding saying that the security guy said that he hit him with a bottle and the hookah bottle, and a videotape was shown that he didn't actually do it, but he had the hookah bottle in his hand. So that was a situation that happened, right? So the federal government in California decided to request the judge to revoke his probation, right? And they had a hearing on July 13th, last month. And the judge basically said there is probable cause to revoke his probation. So, on September 25th, he has to show up to court. And if they have any evidence to help him out. So right now the judge has ruled. And the ruling the judge did was basically that he did violate the court, his probation. But before we go into that, I'm going to go over what evidence that the government did bring in, not only with the situation in Texas, but here was some violation within his own reporting. Okay. One of his drug tests, the first one he did since his probation, he failed the drug test. He tested dirty P. That, and as well, he went out of state without getting permission from his probation officer. So on the 25th of September, he has to show cause. Well, he has to meet up with the judge. And you know, our boy is supposed to be there, y'all. Dom K is supposed to be there for us. We'll see if he shows up and be there for us, right? So we're going to have boots on the ground in California for Boosie's hearing. But what I wanted to do, I do have the documents from the court, because I went and I paid for that document, and I wanted to show you guys what was actually reported, and we can go over that for us to hold on a second. Hold on. Okay, but let me go ahead on and read the petition part for you guys. Hold on a second. All right, let's go ahead on and let me share this part with you guys. Right here, it says, minutes entry for proceeding held by Judge Kathy Ann Benvincigo. Initial appearance, revocation of supervised release as to Torrance Ivy Hash, held on July 10th, 2026. Defendant appearing out of custody. Arraigned and general denial entered. Okay. Retained counsel Megan Blanco appearing. Court having asked if the defendant had any evidence to present on the merits of the position, and after considering any such evidence, the court found basis on the allegation in the petition that there is probable cause to believe that a violation has been committed. Court ruling is without prejudice. Without prejudice mean they can go ahead on and ask for reconsideration. So with prejudice, is that is a done deal and that's it. But without prejudice, the defense can go and bring other things to help change the judge's mind. All right. Court denies the request to limit travel to Georgia. See, the government was asking the judge to deny his travel back to Georgia, but the judge denied it, and they were waiting for the September 25th day. See, if you see right here, it says status hearing set for 9/25/2026 at 10 a.m. in courtroom 15A by Judge B. I'm just going to say Judge B. So, but I do have the documents from the federal government that they had. There's a lot of things that they said that Boosie violated, and that's why it convinced the judge to rule against him and for him to turn himself in. What they're asking for him to spend time in jail for 18 months. That's what they're asking, 18 months jail time for him to spend in jail. So we will see. Let me also show you what else that they allege that he, hold on a second. Hold on. Let me pull it down. I could get this and close this out. There's always so many. Okay, hold on a second. We don't want that one. We don't want that one. Let's go in here. Hold on a second. We got all these files that's open up. And I want to go ahead and close this out. Hold on a second, Joe. Close that out. Go to recent. Hold on a second. We gotta go. All right. So all right, here we go. Let me just go ahead and open the rest of them here. Okay, let me go ahead and open this for you guys to see what they are saying. You said, haven't he learned his lesson? I guess not. I guess not. All right, here we go. What am I looking at? Am I looking at this one here? Is that it right here? All right, this is it, okay? It says here, Terrence Ivy Hash, right? And the docket number. And then it says the judge's name and everything. And the amount of time he served 10 days following his 3-year supervised release, right? That's what he served back then. All right, so, all right, here we go. This is the allegation of non-compliance, okay? And mandatory, not committed to another. This is what they told him. They said his mandatory condition was not to commit another federal, state, or local crime, okay? It says on May 24th, 2026, Mr. Hash committed a new law violation, aggravated assault with a deadly weapon, a felony, in violation of Texas Code 22.02 as evidenced by the Houston Police Department report, and gave the report number. Here's the grounds for revocation. As to the allegation. 1. I received and reviewed the violation report prepared by the U.S. Probation Office in the Northern District of Georgia, Houston Police Report number, and the criminal complaint filed by Harris County, Texas, which verify the following. In summary, according to the warrant affidavit, on May 24, 2026, an officer with the Houston, Texas Police Department was notified of an incident which occurred at 1720 Main Street, Houston, Texas 77002, and it's called the Dome nightclub. According to the police report, the victim advised that at approximately 2 a.m., he, the victim, was employed as security guard at the nightclub. He assisted with clearing patrons from the club at closing time. While the victim was escorting patrons, a female approached him and requested to use the restroom. The victim advised restrooms were closed for the night. The female became upset and intentionally struck the victim in the face with her elbow. The victim then escorted the female towards the exit. She dropped her cell phone and keys onto the floor. The victim bent down to pick up the female's belongings, and he suddenly felt an object strike the top of his head, which caused immediate pain and injury. The victim turned around and he observed blood running down his face, and he observed Mr. Hash holding a broken glass hookah base in his hand. The victim believed Mr. Hash struck him with the hookah base, which caused the injury to his head. As a result of the injury, the victim was transported to St. Joseph Hospital for medical treatment. He received 8 staples in his head, and the victim stated he experienced pain from the injury and wished to pursue charges against Mr. Hatch. Another individual employed as security guard at this location reported witnessing the assault. In his statements to the officers, he reported that he assisted the victim with escorting the female out the club. He reported that after the female dropped her belongings on the ground, the victim bent down to retrieve the belonging, and he heard glass shattered. After immediately hearing a glass break, he observed blood disappearing onto the floor and the surrounding area along the fragment of glass from the hookah base. When he turned towards the disturbance, he observed Mr. Hash holding a broken glass hookah base in his hand while yelling to the victim. The victim and the additional security, both guards, identified Mr. Hash by his stage name, Boosie Badass, by pointing at his picture on the big screen inside the club. The victim and witness stated Mr. Hash was the host for the club. When officers arrived at the nightclub, Mr. Hash fled the scene and was unable to be located. A warrant was filed, and according to the assistant district attorney with Harris County, Texas, a criminal complaint cause number 1965658 was filed outlining charges for aggravated assault. On June 1st, 2026, Mr. Hash appeared with counsel in Harris County. The judge set a $85,000 bond with condition. Mr. Hash's next court appearance is on September 15, 2026. Standard condition: the defendant must not knowingly leave the federal jurisdiction where the defendant is authorized to reside without first getting permission from the court or the probation officer. Okay? On or about May 24, 2026, Mr. Hash knowingly left the federal jurisdiction district and traveled to Southern District of Texas without prior approval of the court or the probation officer, as evidenced by the Houston Police Department report number 667447-26. Grounds for revocation. As to allegation 2, I have received and reviewed the violation letter prepared by the U.S. probation officer in the Northern District of Georgia, the Houston Police report number 667447-26, and the Southern District of Texas, as evidenced by his presence in Dome nightclub. 1720 Main Street, Houston, Texas, 77002. According to an open source information, Mr. Hash, Boosie Badass, was scheduled as a headliner at Dome nightclub May 23rd and May 24th of 2026 from 10 p.m. to 2 a.m. Mr. Hash did not request for approval from his assigned probation officer nor the court for the out-of-district travel to the Southern District of Texas. On January 15, 2026, the assigned probation officer reviewed the condition of release with Mr. Hash to include the mandatory, standard, and special condition. Mr. Hash was given specific instruction related to each of the condition, specifically that he must not knowingly leave the federal judicial district where he is authorized to reside without first getting permission from the court or probation officer. He acknowledged receipt of the instruction as evidenced by his signature. Mandatory condition. Defendant must not legally possess a controlled substance. Defendant must refrain from any unlawful use of a controlled substance. Submit to one drug test within 15 days of release from imprisonment, and at least 2 periodic drug tests thereafter. Testing requirements will not exceed submission of more than 4 drug tests per month during the term of supervision, unless otherwise ordered by the court. Number 3, on or about January 29th, Mr. Hash used a controlled substance, marijuana, as evidence by the urine sample submitted at the U.S. Probation Office on January 29th, which confirmed positive for marijuana, metabolite, delta 9, and that long word, which I'm not going to even try to butcher, carboxylic acid. Okay? Grounds for revocation. As to allegation number 3, I received and reviewed written laboratory notification from Alere Toxicology Services, which verified the urine specimen provided by the offender on January 29, 2026, confirmed positive for marijuana. Okay? All right. Summary, violation summary, sentencing summary. All right, here we go. On January 9th, the court imposed a time-served sentence, 10-day custody, and a 3-year term of supervised release. On or about January 26, the Northern District of Georgia accepted the supervision based on Mr. Hash's significant and relevant personal and professional ties to their district. Mr. Hash's supervision has been met with some progression and numerous setbacks. On January 15, 2026, Mr. Hash submitted a urinalysis testing at the U.S. Probation Office, and the test result returned positive for cannabinoids. When confirmed with the test result, he admitted that he used marijuana prior to his supervision term. On January 29th, he submitted testing, and the test result confirmed positive for marijuana metabolites, delta, whatever other words. However, when confronted with the test result, he declined making a written or verbal statement at the decision of counsel. So that was twice. He first time they let him slide because he said he did it before. The what's the name? All right. Okay. So let's go. At the time of sentencing, the court imposed a special condition with the order that Mr. Hatch complete 300 hours of community service. Approximately 6 months into the terms of supervision, the client has made no measurable progress towards satisfying the outstanding 300-hour community service obligation. Mr. Hash appeared before the court on serious allegation involving a violent offense of aggravated assault with a deadly weapon. As such, his overall adjustment to supervision is considered poor. Offender's personal history characteristic. Mr. Hash, a 43-year-old of age, is 43 years, I'm sorry, something stuck in my teeth. All right, Mr. Hash is 43 years of age. He has resided in Palmetto, Georgia, with his girlfriend and children. Mr. Hash has fathered 9 children and financially support most of his children. He owns and operates his own recording business, which has provided him a lucrative lifestyle. He has been a performer and artist from the young age and continued to earn a living performing throughout the United States. The defendant has an extensive criminal record dating back to his formative teenage year. He has prior conviction for violent and nonviolent offenses to include assault, resisting arrest, possession of marijuana, distribution of controlled substance, codeine, possession with an intent to a controlled substance, marijuana, possession to distribute with the intent to produce, ecstasy, conspiracy to make contraband to and from an institution, disorderly conduct, and possession of trihydrocannabinol. I don't know how I said that. At the time of sentencing, he was placed in criminal history category 5. Mr. Hash has a history of polysubstance abuse dating back to the age of 13 and includes the use of marijuana, ecstasy, and codeine. All right. Mr. Hash has a history of, we already read that. At the time of sentencing, Mr. Hash denied current symptoms or diagnosed for mental or emotional health related issues, nor the needs for medication management to address current emotional health related symptoms. He He reported a history of anger and impulsivity, emotions related to situational depression and low mood, and attention deficit disorder. Sentencing of option custody. Statutory provision. Upon the finding of a violation, the court may modify the condition of supervision, extend the terms if less than the maximum authorized term was previously imposed, or revoke the term of supervised release. 18 U.S.C. 3583 E 2 and 3. If the court revokes supervised release, the maximum term of imprisonment upon revocation is 24 months. 18 U.S.C. 3583 E3. USSG provision. USSG 7C1.1b PS indicates that where there is more than one violation of condition of supervised release, or the violation includes conduct that constitutes more than one offense, the grade of violation is determined by the violation having the most serious grade. In this case, the most serious conduct involved aggravated assault with deadly weapon, which constitutes to a grade B violation, USSG 7C1.1A2. P.S. Upon finding of grade B violation, it is often appropriate for the court to revoke supervised release. The court should conduct an individualized assessment taking into consideration the grade of the violation and to determine whether to revoke supervised release. USSG 7C.3b. A grade B violation with criminal history category 5 determined at the time of sentences establishes an imprisonment range of 18 to 24 months. USSG 7C1.5 PS. Pursuant to USSG 7C.3 PS comments in 2, upon a report of noncompliance or findings of a violation, the court may take any appropriate action provided under 18 U.S.C. 3583, which include extension, modification, revocation, or termination of supervised release. If revocation is not statutorily required, the court may also consider an informal response, which as issuing a warning while maintaining supervised release without modification, continuing the violation hearing to provide the defendant time to come into compliance, or directing the defendant an additional resource needed to come into compliance. Finally, any term of imprisonment imposed upon revocation of supervised release generally should be ordered to be served consecutively to any sentence of imprisonment that the defendant is serving. USSG 7C1.4 B PS. Reimposing of supervised release. If supervised release is revoked and the offender is required to serve a term of imprisonment, the court may reimpose supervised release upon release from custody. The length of such a term shall not exceed the term of supervised release also authorized by a statute for the offense that resulted in the original term of supervised release, less than term of imprisonment imposed upon revocation. 18 U.S.C. 3583H. In this case, the court has the authority to impose a term of 36 months supervised release less any term of imprisonment imposed upon revocation. 18 U.S.C. 3583B. Justification for bench warrant. Mr. Hash has been shown an unwillingness to comply with the basic condition of supervision. His recent conduct is violent in nature and has allegedly resulted in physical injury to another individual. Given the seriousness of the conduct, coupled with Mr. Hash's criminal record, history of weapon possession, violence, and illegal substance use, he poses an immediate risk to himself and the community. Therefore, the issuance of a warrant is respectively recommended to bring him before the court to face the allegation noted herein. Recommendation. Justification. The present matter represents Mr. Hash's first violation proceeding in this case. At the time of sentencing, Mr. Hash has entered a plea of guilty in violation of 18 U.S.C. 922G1, felon in possession of a firearm and ammunition. The guideline range at the time of sentencing was 24 to 30 months custody. Despite the significant guideline exposure, the court exercised considerable leniency at sentencing, imposing a time-served sentence of 10 days custody, followed by a 3-year term of supervised release. Unfortunately, the defendant has failed to capitalize on the opportunity afforded by the court. Within weeks of starting supervision, he exhibited a pattern of non-compliance. He has failed to adhere the most basic monitoring restrictions. His conduct demonstrates a disregard for the court's authority and unwillingness to comply with expectation established to facilitate a successful transition to the community. Additionally, his history reflects long-standing involvement in a criminal lifestyle, beginning at a young age. This lifestyle has continued to expose him to high-risk situations and criminogenic influence, including violence, weapons possession, anti-social peer association, and illegal substance use. In determining an appropriate sentencing recommendation, an underlined has considered the 18 U.S.C. 3553 sentencing factor and goals, the nature of the noncompliance, and the supervised individual risk and needs, which include criminal history involving violence, substance abuse issues, history of noncompliance to including travel out of the district without permission, weapons possession, and lack of pro-social support. The conduct alleged under Texas Penal Code 22-02, which is analogous to California State Penal Code 2245, based on applicable statutory definition and relevant case law, does not constitute a crime of violence grade A grade B violation. With criminal history category 5, determined at the time of sentencing, establishes an imprisonment range of 18 to 24 months. After a careful and individualized assessment of the case, The undersigned respectively recommend an 18-month term of imprisonment, a low end of the guideline range, consecutive to the custodial sanction imposed by Harris County, Texas criminal cause number 1965658, followed by 18 months supervised release. The undersigned also recommends the imposition of all standard and special condition imposed, as they will allow the probation officer to effectively monitor the supervisee in the community and keep abreast of his activity, except for the condition that orders Mr. Hash to complete 300 hours of community service in a program approved by the probation officer. Mr. Hash has shown he has no intention of completing community service hours. Submitted to search. Further, the undersigned recommends the court to impose the following special condition. Submit to search of a person, property, house, residence, office, vehicle, paper, cell phone, computer, or any electronic communication or data storage device or media effect conduct by the U.S. State, the probation office, or any federal, state, or local law enforcement officer at any time with or without a warrant and with or without reasonable suspicion. Wow. Failure to submit to such a search may be grounds for revocation. You shall warn any other residents that the premises may be subject to search pursuant to this condition. This condition is needed to mitigate risk to the community and facilitate the supervised transition into the community, support his rehabilitation, and promote public safety. I declare under penalty and perjury the foregoing is true and correct. Wow. Y'all. Mm, mm, mm. She did not agree with the bench warrant. She disagreed with the issuance of a summons ordered the offender to appear. So she gave him a summons for him to appear, but she disagreed to the bench warrant. But his next court date is on September 25th, 2025 at 10 a.m. Hold on a second. Oh, sorry. All right. So that is update on Boosie's case. So he has to go to court on the 25th of September. Now, let's go on to our next case. Our next case is Cecil McCrary. Oh, my teeth hurts. I just did something and I got my teeth hurting again, y'all. I think I better go use that toothpaste. I just did something. I did something. It's a T on the side here. Oh, all right. Cecil McCrary has a calendar for trial for August 26th. Okay. Let me just make sure. Hold on a second. Get some clove oil. I don't have clove oil. I don't even know where to get clove oil from. Let me see. They got it at Walmart, it says. Huh? It says clove oil in Walmart. Where is it at? They said it got clove oil. Yeah, they got it at Walmart. I'll go get some. All right, so I'll go get some. Oh, hold on. Tall glass says, hold on a second. Says, Sassy, I heard that, but when was the deadline to complete the services? There's no deadline. How they... I thought the deadline was, I thought they did say a deadline. I thought they did have a deadline on there. I think there was a deadline. They usually have a deadline for those things. Hold on. Hold on. Let me see. Hold on. Hold on a second. Let's see. Hold on a second. Let's see. Let's see. Community service. Hold on a second. I'm looking, y'all. I'm looking. It doesn't show the time. It just says it has to be approved by the probation officer. So they're gonna have to give him a set time then. Yeah, Tupac's trial has started. You got it from Walmart. Does it work, Miss Richard? My teeth wasn't hurting until I did something just now. I felt something stuck in it. Oh, Tall Glass, thank you for the Cash App. Oh, thank you so much, Tall Glass. I appreciate you. Okay, so let's go ahead on to Cecil and tell you what's going on. Got a couple of cases that hold on. Let's go to Cecil, Cobb County. Let's go tell you what's going on with Cecil. No, I don't want that. All right, here we go. Okay, it says here jury trial August 31st, 2026 at 9 a.m. But he has court date on the 26th of August. So I will be there for that. And I'll tell you whether or not. So we're going to put that on our calendar. The 26th of August for Cecil. All right, 26th of August. Put that down on your calendar, y'all. I will be at Cecil's hearing. All right, the 26th of August. I got to be there early in the morning. All right, that was Cecil's. Now, Josh has a trial coming up as well. Come on now. Why is it not opening up? Come on. Okay, we're good. Sorry. Josh has a trial for his fight that he had in the penal system. And his trial starts the 24th. No, hold on. Yeah, the 24th of... And he had a... Well, he had a hearing today too. He had a hearing this morning. I missed that because I was at work. But he had a hearing this morning. His trial starts the 24th of August. And then September 28th, he has. Hold on, I gotta call somebody. Hold on a second. Let me call somebody. Hold on. Yeah, I saw he got to change the venue. I saw that. I saw the approval for that. The judge ruled for him to change the venue. Oh, God. Hold on a second.
Please leave your.
Okay, sorry about that. All right, so I'm waiting for the call back on that one, okay? Regarding Josh's trial date. So we have two trial dates for him. We have one the 26th of August, and then we have the 28th of September. So we have two trials. One It's for the penal charge, and the other one is the one that we originally started covering, which is the when he unalived someone who came into his home while he was sleeping. Okay, that was Josh. Okay, now I was checking for Lacey's Bowles situation, and what I got was with Paulding County. Hold on a second. I hate when it's do that. I hate when it does that. Hold on a second, y'all. I really don't know what happened with that juror. I probably need to look up that juror, see if he has a case number. Hold on, let me check and see if that juror has a case number. Hold on a second, y'all. Remember, I didn't go to the Rule 22 that I had on that one, and I was approved for my Rule 22. I am so upset with myself that I did not get a chance to get that. I am so upset that I did not. See, they gave me the whole thing. Judge Lyles. See, y'all? Look, see, Judge Lyles had given me my Rule 22 approval, and I did not have the opportunity to even take advantage of it. See? Yeah, see? Gave me my Rule 22. See, it was approved. But I didn't even go. So, I'm so upset. See? It says granted. He granted it. See? Granted. My Rule 22 was granted, but I didn't even go. Dang on it. I didn't go, so I don't know what happened to that juror. I don't know if he got what the judge did with him. But maybe I can find out. Maybe I can find out. Hold on a second, y'all. Let me see if I can. Maybe, is it too late to text? Mr. Steele's all the way in California right now. Is it too late to text him? I know he's busy with the little Dirk case. I'll just leave it alone. I'll just wait till. Let me text the other attorney and find out what was the status of that. I can go down to the courthouse and request it. But do I want to drive all the way down there? But see, okay, let me see if I can get his name. Let's see. Hold on a second. Y'all. Let's see what I can do in the Rule 22. Let's see. Hold on. Let me see. I got it. Let me see if I can search his name. Because I don't think nobody went to his thing. Hold on. Let me see if I can search by his name. Uh-oh. Uh-oh. Oh, he got old stuff. He got stupid charges back in the days. He got dumb charges, like failure to yield when entering a crossroad. Yeah, he got stupid stuff. Yeah, I don't see anything from the judge. Mm-mm-mm. I don't see anything in there. Yeah, I don't have no clue what happened to him at the court. I have no clue, y'all. So I'll have to reach out to the attorney tomorrow and find out if I'll give him a call. Okay, now the next case we have was I was trying to see if that young lady they have a court date for her yet. Let's see. As I can see here, there's still nothing new for Miss Patrick. Sarah. I don't see anything for her yet. Oh my God, she'll give me a whole bunch of counties. Carroll County. We want Carroll County. Hold on a second, y'all. Nothing has been done for hers yet. Nothing. Nothing. Okay, so, and now let's see if they have done anything with Ernest William. Let's see if anything has been done with his yet lately. Because they were supposed to come up with a date. Yeah, I broke my phone today, and I cannot see stuff that's on my what's the name? I can't see nothing on it. It sucks. All right, hold on. Let's see what we got for Ernest Williams. I think it was number 3. I think it was number 3. Yep, it is number 3. There's still nothing for them. Man, I'm telling you, if they didn't do it right away now, it's not going to be until next year if they don't have a date by now for most cases, because holidays are coming and a lot of courts personnel going to take vacation and stuff like that, so it's going to be rough. It's going to be rough for Mr. Ernest. There's nothing out here for him. Yep, nothing out here for Ernest. But next week, I have the case where Chaotic, you know that guy from the reality show. I'll be going to his hearing. He has a bond hearing. He got bond for one of the cases that he got bond, but it seemed like there's another bond hearing for him. I don't know why. First one was 100,000, so I don't know what's going on with that one. They give him bond for 100,000. Let's go check it out. Let's go here. I have the case number right here. Hold on, let's pull up the case number. I have started putting my little cases on the side with my little notes. We got his case right here. Let's see. And he also has another case. Let's put it. Let's see. Let's see. Boom, 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 boom. This is his bond. They gave him a bond. Hold on, let me show you his bond. Let's see. Let me show y'all what his bond is. This is his bond right here. They gave him $100,000 bond, right? Have you received? You will receive a notice in the next court date if you change your address. Blah 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 blah. Okay, it says here. Other condition: defendant is subject to curfew during the time he must remain in his dwelling, and the address which is provided by pretrial. It says no contact to the defendant. He has a curfew. It's from 10 p.m. to 5 a.m. He has to be in the house. He must surrender his passport. He must wear an ankle monitor, electronic monitor. He shall not have direct or indirect contact with any victim's family, or close associate by phone, email, mail, social media, or through any third party. If you encounter the victim, you must immediately leave and must not come within 200 yards of the victim. Enter the victim name. Her name is Mariah Wortham. So that's it. So that's his pretrial. All right, that's his. And his next court date is on the 25th of August. August 25th is a busy, busy day, isn't it? Wasn't that Cecil's day? Well, Cecil's was the 28th. What day was Cecil's? What day did I tell y'all Cecil's thing was? And Josh. Josh was 26th of August. What day was Cecil's? Did anybody remember? Y'all, have you guys been watching the Tupac trial? I will be watching it here on my channel tomorrow. Cecil's is the 26th too? Hold on, let's go back to Cobb County. Let me go to Cobb County. Hold on. What was the other guy's name, y'all? And the other case in Fulton County? Let me see. What was the other guy's name? Let's see. Hold on a second. My throat itching. Hey, Bray. Rick Bray. Y'all, my throat itching. All right, and we get back to Cobb County. Okay, let's go search. Let's see, what's Cecil's date, y'all? Cecil's was the 26th. You were right. You were right. Yep, Cecil's was 26th. Thank you, Natalie Lynn. You were right, Natalie Lynn. Okay. All right, y'all. I'm about to get off this live, and I'll check you guys tomorrow. I'll be here doing the trial with you guys. Have you guys been watching Keefy D's trial? Have you guys been watching it? Tall Glass, have you been watching it? I know you're on vacation, but have you been watching the trial? In and out, okay. I was listening to the part where while I was driving home. I was listening to the part where they was playing the recording. And they were asking about some car. So I didn't get the logistic about that. All right, yeah, I'm getting sleepy. I gotta go goggle and get this thing out of my teeth. And probably go get some of that oil that she talked about. All right, y'all. I'll check y'all later. Good night, everybody. I'll see y'all in the morning. Bye.
Thank you for watching the Infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pain. click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night.